Now, over the years, I've done quite a lot of thinking about the subject of tenancy agreements, and I think there are three main purposes that we have for tenancy agreements, which reflect three areas of law which apply to tenancies. And the first one is title, because a tenancy is a form of ownership of land. If we go back to the Law Property Act 1925, that states in Section 1 that there are two types of ownership of land that you can have in law. The first of them is an estate in fee simple, which is freehold land, and the second is the term of years, which is a lease or tenancy. People often think that means just long leases, but it's equally relevant to tenancies. So a tenancy agreement is a document of title. It's the document that transfers the legal title, the legal tenancy, to the tenant. But it's also perhaps the least important aspects of the tenancy agreement, because from that point of view, it's not necessary. Now, going back again to the Landlord Property Act 1925, that act says that when you are transferring or creating a legal interest in land, it needs to be by deed. But the Act also says, in section 54(2), that for certain types of tenancy, there is an exception, and it doesn't have to be by deed. And it sets out the circumstances where you don't need to have a deed to create your lease or tenancy agreements. And this is basically if you have a term not exceeding 3 years, if they go in immediately, if they've got a rent, and if there's no fine or premium. If you have a long lease, you normally have a payment for the lease, and you don't have that for tenancies. So in most cases, if you let someone into a property on a handshake, an agreement that they'll pay you £750 a month, and they go in, that is a perfectly valid tenancy that's been created. It doesn't need to be created by deed. So although the tenancy agreement is a document of title, it's not particularly necessary. The next one is terms, because a tenancy is also a legally binding contract between the landlord and the tenant, and it is subject to the various provisions of the law of contract. And so a tenancy agreement is very important because it sets out the terms and conditions under which the landlord agrees to rent the property to the tenant. So you need to have all the terms and conditions set out in your tenancy agreement. And you also need to have terms and conditions that will protect the landlord's position. And this is very important for landlords. And I want to talk about two clauses in particular where it is important for a landlord to have a tenancy agreement and where a landlord will be prejudiced if they don't have one. And the first one is rent. And I think not a lot of people realise that actually, by default, rent is payable in arrears. So if you let someone in on a handshake into your property, the default common law rule that will apply is that rent is payable in arrears. Now, we all think of rent as payable in advance, but the reason for that is you have a tenancy agreement, and practically every tenancy agreement that you'll have will specify in it that the rent needs to be payable in advance. So that is one very important reason why you need to have a tenancy agreement. Otherwise, you can't insist on rent being paid in advance. I've got a sort of story about that. I've got a little online course that is available for free for landlords, and one part of the course is on rent. And one of the people on the course emailed me and he said, "What's all this about rent being paid in arrears? Where does that come from? Can you tell me the law that it comes under?" Which is very difficult because it doesn't come under any statute, it comes under the common law. And the common law is that the legal system that's been built up over hundreds and hundreds of years, from way back before William the Conqueror, with customs and judges' decisions, and it builds up like leaves in the forest floor. And that's where it comes from. And I sent a tweet, being a modern woman, I sent a tweet out to various barristers that I know and said, can you tell me where this rule comes from that says that rent is payable in arrears by default rather than in advance? And they sort of scurried around. They said, well, it definitely is, because it's implicit in all the decisions. And they gave me a couple of cases, which I went and had a look at, were sort of 19th century cases. And yes, it was sort of implicit. And I was talking about it to Graham, and we thought that perhaps the reason where it originally comes from is that many years ago, most people had agricultural tenancies, and they would pay their rent from the crops. And of course, you can't pay the crops until they're grown, so they go in, and then after they've been there a while, the crops will grow, and they'd use that to pay their rent. So that's probably where it comes from originally. We don't know, this is just speculation. So that's a very old established common law rule that rent is payable in arrears unless you specifically say in your tenancy agreement that it's payable in advance. So make sure that in your tenancy agreements that it does actually say that. The other clause that I want to talk about that is really important that you have in your tenancy agreements is the deposit. And it's the general axiom of having a deposit that the deposit money belongs to the tenant. It's not the landlord's money, it's the tenant's money. And if there's an adjudication, it always starts from that point. It is the tenant's money. So it's very important that you have in your tenancy agreement a clause which sets out the circumstances under which you will make deductions from the deposit. Because if you don't have that in your tenancy agreement, you're not actually authorised to make deductions from the deposit. It only needs to be, essentially what it needs to say is that the landlord will make deductions for any loss or compensation as a result of the tenant breaching the terms of the tenancy agreement. And that will sort of cover everything, including non-payment of rent. But it's very important that you have that, because if you don't, say for example you let someone in on a handshake and you've just got an oral tenancy and you take a deposit and you want to make a deduction from the deposit and they object to that and it goes to adjudication. If you haven't got a tenancy agreement clause which specifies how you can make deductions, the adjudicator is going to throw it out because you've got no authority to make the deductions. So those are two really important reasons why it is essential that you do have a tenancy agreement, and you need to make sure that the tenants sign it before they go into the property. Because once they're in and they've got the keys, they can turn around and refuse to sign it, and you can't force them to sign it against their will. And if they're only going to stay there for 6 months and move on, they've got no incentive to sign it. So it's very important that you make sure that people sign it before they go in. It's also important that you take care that the clauses in your tenancy agreement are correct and the information in the tenancy agreement is correct. For example, if the rent is £750 per month and your secretary puts, we always blame the secretaries, don't we? Apologise to any secretaries here. The secretary puts not hearing you properly on your audio tape, perhaps, because you've been mumbling, £700 a month. And that is the agreement that's produced, and that's the agreement that both parties sign. If you then look at it and think, well, hang on a minute, they're supposed to be paying £750, you can't alter that unless they agree. And again, there's no reason for them to agree, so you need to be really careful and check it carefully and make sure that it is correct. Often they will agree. I mean, if it's the other way around, they probably agree. But if it's in their favour, there's no reason for them to agree to alter it. So do be careful about that. Okay, the third purpose of a tenancy agreement, and the third sort of area of law really that applies to tenancy agreement is perhaps a fairly new one, and this is as a tenancy as a consumer service, because tenancies and provision of rented property is increasingly being seen quite rightly as a service. It's a service industry. It's not so much an investment. You are providing a home to tenants. And it's a service to consumers, and so the consumer law will apply to your tenancy agreement. And the tenancy, ideally what the tenancy agreement should be, is a guide to both parties about the tenancy, setting out all the things that they need to know, information about their tenancy, so they can use it as a reference to refer to if anything goes wrong, as a sort of tenancy agreement manual, which I think is a very important aspect of a tenancy agreement. So as a consumer document, there's sort of three things that we need to think about. We need to think about what is actually covered in the document, its contents, and the wording used. Is it clear or is it confusing? And also, you want to consider the actual appearance of it. Is it easy to read? Is it clearly laid out? Is the numbering confusing? Is it easy for the tenant to read? Because if the tenant can read it and understand it, they're more likely to use it and refer to it and use it as a working document, which it should be. So I suppose there's a bit of a tendency among lawyers perhaps to think more of it as a document of title and a contractual document, perhaps rather than the consumer side of it. There's also a tendency among lawyers not to change wording because we like it if there's a certain form of wording that's been tested in the courts, because we know what it means. And if you make up new wording, it hasn't been tested in the courts, you don't know exactly what it means. But I think we're probably going to have to move away from that side of things. There's some chairs at the side there. I think we're going to have to move away from that side of things, because I'm going to come on to talk to the unfair terms in consumer contracts regulations. Well, we can't have these old-fashioned form of wording. It's got to be modern. It's got to be easy for people to understand. So this is a bit of a challenge to the draftsman, producing a tenancy agreement which complies with the old rules but is written in a way that ordinary people can understand.